if you are a company and you are contemplating hiring away talent from your rivals or competitors, whether it's one person, whether it's several people, particularly if it's several people, whole groups and teams, there are several very significant considerations you have to bear in mind. The first is that everybody has a non-compete agreement. Non-compete agreements have become ubiquitous. This has happened over the past, I'd say, 10 years, maybe 15 years. There has been a dramatic rise in the amount of litigation over non-compete agreements. And this is not anecdotal simply from my perspective. This is actually based on a statistical analysis of court dockets, and the number of non-compete cases, non-compete litigation has increased steadily over the past decade. So it is a matter of factual record. We have more non-compete cases than we did 10 years ago. And consistent with that, in my view, more and more people are subject to non-compete agreements. Every week, I try to read as many non-compete cases from around the country as I can to give me a broad overview of what's being litigated out there. What types of non-compete cases are there throughout the country? What industries do they involve? What businesses do they involve? And I have seen non-compete agreements at every level of every industry. I have seen them for media personalities, doctors, chefs, massage therapists. I have even seen a non-compete agreement for assembly line workers in a factory. I've seen them for maids. I've seen them in all sorts of different sales capacities. So non-compete agreements are ubiquitous. And if you are a company and you are sizing up a rival and saying, they have certain people who we would like to hire, we'd like to bring on board, we think they have a lot of value, the first thing you have to be aware of is these people most likely have non-compete agreements that are designed to prevent a rival like you, particularly one that's hungry, well-capitalized, aggressive, looking to grow, to prevent you from stepping in and poaching their best people. Now, obviously, you have to take geography into consideration, because if you're located in California, then simply doesn't apply to you. Your targets, your employees of the rival who you want to hire away, they don't have non-compete agreements, but that doesn't mean you can't get sued for trade secrets. So, number one, you always have to be cognizant of the fact that employees you are targeting to lure away from a rival, they likely have non-compete agreements. Number two, in connection with the fact that they have non-compete agreements, if you hire them away, you have exposure for, one, tortious interference with that contract, tortious interference with that advantageous business relationship, and then you possibly have exposure predicated on a number of other theories. You may have exposure, for example, in Florida, you may have exposure under the Deceptive and Unfair Trade Practices Act. California has a similar sweeping 17200. You may have exposure under something like that. Or if you have a tremendous amount of market share, and this is very unlikely and would only happen in certain very rare instances, but if you had a tremendously high market share, then you could also have potentially some exposure under the antitrust laws if you were some sort of monopolist. But again, that is highly unlikely to happen. So in most instances, you have to be cognizant that there will be non-compete agreements at issue, and two, you have to understand your exposure vis-a-vis those agreements is for tortious interference or possibly some sort of unfair trade practices. So that's number one. Number two, you have to examine the geography, because the geography is, in many instances, going to be dispositive. That sounds crazy. Let me get into it. We have non-compete agreements. I'm looking at a team of employees. I run a manufacturing company. I want to hire some engineers away from a rival. They are based in Detroit, Michigan, and I want to hire them to come over to my plant that's also in Detroit, Michigan. Okay, well then there it's simple. You're just looking at Michigan law. Or there's a team of employees who are located in Chicago. I want to hire them and bring them into Indianapolis. Well, in all of these situations, you have to go to the actual employment agreement, the actual non-compete agreement, and you have to see what the contract indicates for choice of governing law and venue. Because you may have employees who you're trying to hire in Michigan, in Illinois, in Florida, in Pennsylvania, wherever they're based. They may be based somewhere physically, working there physically, in a facility, in an office, in a factory, whatever. They may be based somewhere, but their agreement may say that venue and governing law is somewhere entirely different. There was a recent case out of the District of Minnesota, the federal court for Minnesota, where the employee was working in Minnesota, and if I recall correctly, the choice of law provision indicated that Florida law would be applied. And the court said, no, there's no connection here to Florida law whatsoever. We're simply not going to apply it. So you have situations where people have non-compete agreements. They might be located in one, city or one state, but their non-compete agreement may call for the application of an entirely different state law. Why is this important? It's extremely significant in the non-compete context because there is dramatic variation from state to state with respect to the rules that govern enforceability of restrictive covenants. In my view, this arena of law differs more from state to state than perhaps any other body of law. You have certain states, for example, Illinois, in my experience, New York, certain states where they will enforce non-compete agreements, but they will do it in a very limited manner, and they will subject those agreements to fairly rigorous scrutiny. I have seen a number of cases out of Illinois, and there was in fact a recent case out of the New York Appellate Division, striking down a non-compete agreement. The one out of New York recently, it was called for to apply Florida law, and the court said they find Florida law of non-compete agreements. They basically said they find it preposterous and offensive, and they're not going to apply Florida law. So that's just a little insight into the sort of broad variation that exists among the states. You can have one fact pattern, okay? You can have employees that work at this company, they have non-compete agreements. Here's what they do in terms of their job capacity. Here is the confidential information that they may have been exposed to. Here's the projects they were working on. Here's the software they were developing. Here are the customers they were dealing with. You can take these facts, and in Illinois, a non-compete agreement may be entirely unenforceable against these people. And in New York, it may be entirely unenforceable against these people. But in Florida, where courts tend to be more pro-non-compete agreement, the law tends to be more pro-non-compete agreement, it may very well be enforceable. So, given that sort of variation, your analysis, your strategy in hiring away employees of a rival or a competitor in your industry has to begin with a thorough assessment of who the targets are, who you want to hire, where they are, what their contracts say, what is the choice of law, is the non-compete agreement going to be enforced under that choice of law, or alternatively, is there some principled way in which to challenge that choice of law? You're in Minnesota, you're trying to hire some employees who also work in Minnesota for a rival. They work for a Florida company that's got an outfit in Minnesota, and their contracts say Florida choice of law. It's quite plausible that the federal court in Minnesota is going to say, we're not applying Florida law because there's no connection to Florida. Any connection is too attenuated. We're going to apply Minnesota law, which is much more favorable to the employees. So that's what your approach needs to look like. Who are we hiring? Where are they based? Where are their contracts? Review their contracts. What's the choice of law? What's that law look like? If it's good for us, great. If it's bad for us, can we challenge it? That's the first half of the process. The second half of the process involves actually bringing the people on board and hiring them. So if you have done this entire analysis, this entire process, and you've decided it is worth the risk to hire these people, there's a whole second set of steps that you need to take. But let's be very clear. When you do this analysis, you need to understand that even if you run the analysis and you conclude that the non-compete agreements should be unenforceable and therefore there should be no claim against you for tortious interference, for unfair competition by hiring these people with non-compete agreements. Even if you do that analysis and you conclude that you should win, you should prevail on the merits, there are no guarantees in anything. There are no guarantees in business, there are no guarantees in life, there are no guarantees in litigation, most certainly. So when you hire away rivals or employees of a rival, you should expect that there will be litigation. You should expect that the other side, if they are a company of any significance, is very likely to send you a cease and desist letter and seriously contemplate suing you. If you steal somebody who is super talented, super valuable, a big-time contributor, you should expect that they will come after you. And if you steal a number of people, if you steal a team of people, and I use the word steal, but I obviously don't mean that. I do mostly defense side work in these cases. So you poach these people, you raid a team or what have you. You take a number of employees, you should expect that you will be sued. So you have to go into this with open eyes and with some sort of strategy. You run the analysis, and if it looks like you will lose, if it looks like you don't plausibly have a case against this, then you need to go an entirely different way. If it looks like you can't fight this, you can't win, you have to understand you may be enjoined. If you can't fight this and you can't win, you don't have a plausible case, you may be enjoined. These employees who you're looking to hire, if they come over to your company, the other side sues you, the other side may obtain an injunction, shutting you down or shutting these people down, preventing them from doing any work for you. So you've hired these people, they're sitting there, they're now basically dead in the water, they can't do anything to help you. And if you somehow try to be clever and work around that, there's the possibility that you could be found in contempt of an injunction. So that's why you do the analysis, you know what you're getting into before you make the decision to hire people. But if you understand the risks, you've done the analysis, and you say, it's a gray area, we could possibly win, we could possibly lose, but on balance it's worth it. We will hire these people. You hire those people. When those people come in the door, there are certain steps you can take to somewhat insulate yourself from liability. Now, this is obviously not foolproof. This is not going to prevent the other side from suing you. It is, however, going to give you a bit more credibility in front of the court, and it's going to be some good optics on your side. What's this involve? This involves bringing the people in, the new employees in, and having a thorough intake process in which they answer a bunch of questions pertaining to their non-compete agreements, right? They answer a bunch of questions saying they didn't bring any confidential information with them, they haven't brought any files, any documents, any software, etc. They don't have any access to any of those things at this point. They agree not to utilize any of that. They agree that they are not being employed to make unfair use of the other company's confidential information. They agree they're not being employed in an attempt to solicit the other company's customers. There is a litany of different questions and sort of disclaimers that you can include in writing and have the person sign off on. And then you have, at least from an optics standpoint, you have a sort of record of, no, we hired this person, we knew they had a non-compete agreement, we believed that we could hire them in a way that was fair, we've laid this all out, in kind of, contracts, and, they signed the paperwork saying they weren't going to do anything unfair, and I have in fact seen that work in some very high-level non-compete cases. But it has to be done thoroughly, it has to be done the right way, and it has to be done by an attorney who is experienced litigating non-compete and trade secrets cases. So it's a long talk today, but hopefully it's a helpful one. If you are considering hiring employees away from an industry rival or competitor, you have to consider the fact that all of these employees likely have non-compete agreements. You have to get copies of those non-compete agreements, evaluate them, look at the governing law, determine what your odds are of prevailing under the governing law, and if it's bad, you have to see whether or not it's possible to challenge that choice of law and get a more favorable choice of law. And if you can't, you go back to the original law, and you're left with, is it good, is it bad, is it somewhere in between, maybe a gray area. From there, you can make the decision regarding whether or not the value of these employees outweighs your potential exposure for tortious interference, some type of unfair trade practices, etc. And if you decide that on balance it's worth it, you hire these people, you bring them in, and you put them through some type of rigorous, principled intake process that may plausibly give you the ability to then go into court and say that you hired these people, but you attempted to do it in a manner that was fair, appropriate, and consistent with the terms of their non-compete agreements or otherwise restrictive covenants. Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. If you have a non-compete question, if you have a trade secret question, if you just want to talk about this stuff for 5 minutes, feel free to call my office. I am happy to speak with you and help you if I can.